The court issued an order today about a case called Liberty University versus Geithner, Secretary of the Treasury. It was kind of under the radar. And now this case was a direct challenge to Obamacare a couple of years ago. Liberty University was one of the first organizations to file suit to try to stop it.
Hit Kickin' Country, Z94. Wild Bill in the midday. And joining us is Dean of the Liberty University Law School, Matt Staver. Mr. Staver, it's great to have you on the airwaves here in South Georgia.
Good to be with you today.
I graduated Liberty back 15 years ago, and it's probably been that long since I've stepped on campus. And from what I can tell from friends and family who have visited Liberty in recent years, boy, a lot has changed, and God has really used that university in a huge way.
No question about it. There's a lot going on at Liberty University. If you haven't been there even in 1 or 2 years, you will see a huge change. The landscape is constantly changing. Buildings are coming up. School is expanding. We're just getting ready to add a medical school that will be open in 2014. So there's a lot of activity, a lot of happening at Liberty University.
How did LU get the attention of the Supreme Court of the United States? Walk us through where you're at now in this process.
Well, Liberty Counsel is a national public interest law firm, and we filed suit on behalf of Liberty University and other private individuals on the very first day that Obamacare was signed into law by President Obama back in March of 2010. And I argued the case at the district court, at the Court of Appeals, and then it went from there to the United States Supreme Court. The very first day of the 3 days of oral argument was actually our particular issue that we put before the United States Supreme Court. And then after the Supreme Court made its ruling in June, our case was still alive and active. And so where we will ultimately stand right now is our case is still pending at the United States Supreme Court. The last week of this month, after Thanksgiving, we expect to hear from the United States Supreme Court, at which time we expect them at that point in time to send our case back down to the Court of Appeals so that we can then argue afresh this issue that's never been addressed before by the High Court, namely the constitutionality of the employer mandate. The individual mandate was argued at the Supreme Court. We also had the employer mandate in addition to that. That's never been argued, so we expect that that will be the direction of the court when it goes back to the Court of Appeals, that will argue the constitutionality of the employer mandate. And then we will argue the free exercise of religion claim. And the free exercise of religion claim comes in to this extent. If the employer mandate is unconstitutional, then the whole employer mandate goes out. If they uphold the constitutionality of the employer mandate, like they did the individual mandate, then our next argument is the free exercise of religion clause ultimately prevents the implementation of that with regards to religious employers. And then also on the individual mandate, it also does the same thing with regards to individuals who have religious objections or convictions against abortion. Because this particular Obamacare law requires employers, despite the religious convictions to the contrary, to fund abortion, and even others, for example, Roman Catholic organizations, to provide contraception and sterilization. And it also provides the same thing for individuals, that individuals will have a fee that is required of them that goes directly into a fund that ends up funding abortion. So employers as well as individuals will ultimately have a collision with the free exercise of religion as this thing unfolds.
Well, in June, even though the court upheld Obamacare under regular tax law, the High Court ruled in part that the Anti-Injunction Act did not prohibit lawsuits against Obamacare, did not prohibit them, in fact. So guess what? Liberty refiled for a rehearing with the Court of Appeals. The administration has 30 days under the order issued today to argue why there should not be a rehearing at the Court of Appeals.
Do you believe that this case is a lot stronger than the one that was argued over the summer before the Supreme Court in dealing with Obamacare?
Well, frankly, I think the case was argued over the summer with regards to Obamacare and the individual mandate was exceptionally strong. I think that there's absolutely no way that you can uphold the individual mandate under this Constitution. And the way that the court was originally going for the first 30 days or so, the vote was 5-4 to strike it down under both sections of the Constitution, the Taxing and Spending Clause and the Commerce Clause. But as we now know, Chief Justice John Roberts switched his vote and flipped on the Taxing and Spending Clause. I think that that is completely insupportable by the statute and insupportable by the Constitution. But that's what we have right now. So now this case going up, I think it is very strong, and I think it does have some stronger components even than the other one because it brings in the additional free exercise of religion. Free exercise of religion essentially says, even if it's constitutional, even if it's going to be upheld, then you've got to look at, is there a contravening constitutional provision that strikes it down? And the free exercise of religion shows, in this case, a direct and unprecedented clash with the free exercise of religion. Never before in the history of America have we had such a direct collision with the federal government and the free exercise of religion. Here, what the federal government is doing is saying that it doesn't matter if you're religiously affiliated, if you have a sincerely held religious conviction against abortion for the sanctity of human life, you still must fund abortion. This is not something where you can have your free exercise of religion and continue on with your religious practice and just simply be inconvenienced because of some government law. This is something that collides with a specific tenet of your religious belief, and there is no way around it. You're forced to do one of the other two things. You're forced either to comply with the law and thus violate a tenet of your religious belief, or you're forced to violate a tenet of your religious belief in order to comply with the law. There is no way around it. This is not an inconvenience. It is a collision with religious free exercise under the First Amendment.
Do you think there's a possibility that the justices will look at your case and decide to take out a small part of it, or will they be forced to completely strike the whole thing down together? What are your predictions in regard to that?
Well, either way, if they strike down the employer mandate as it relates to religiously affiliated employers, and or if they strike down the application of the individual mandate as applied to individuals who have religious objections, if they do one or the other, this law is gutted. If you take all the religious employers in the country and ultimately hold that the free exercise of religion protects them, which I believe it does, and therefore you can't force them to fund this contraception, it ultimately guts this law in a significant way. It would force the administration to go back and repeal part of this particular law that requires the forced funding of abortion.
Do you believe this is going to be an uphill battle in convincing the justices on the Supreme Court?
Well, I think all of it is a difficult battle, no matter which way you go, because it's going to be a clash that is of unprecedented character. On the other hand, the Supreme Court just decided a case called the Hosanna-Tabor case, and they decided 9-0, and they rejected this Obama administration's argument that whenever there's an employment situation that you have a minister, you have typically the ministerial exemption. In other words, Baptists can hire Baptists and Catholics can hire Catholics. If you have a pastor or a priest, you ought to be able to take an employment decision regarding them that's consistent with and extends your religious conviction. It's called the ministerial exception. In other words, you can discriminate on the basis of religion. It makes sense that a Baptist can hire a Baptist preacher. A Catholic can hire a Catholic priest. This administration, though, ultimately said, no, that's not permissible anymore. Took an unprecedented position, just like they're taking under this HHS mandate on Obamacare. And the Supreme Court rejected that argument 9-0 and issued a very strong affirmation of the First Amendment right to free exercise of religion. So I think we have that case that just came down this year, and I think going into the Obamacare case, I think going back to the Supreme Court probably in 2013, we'll have the wind in our sails.
Matt Staver, thank you so much for joining us. He is the Dean of Liberty University, and this case is going to receive a ton of attention. Liberty University versus Geithner, hopefully before the Supreme Court, and a ruling fairly soon. Thank you so much.
Thank you. It's my pleasure to be with you.